This podcast explores the workings of the criminal justice system, including the investigation and prosecution of serious offences involving sexual and physical violence. Episodes may contain detailed and sometimes graphic accounts drawn directly from case files, witness testimony and court proceedings, including those involving adult and child victims. Listener discretion is advised. Welcome back to Criminal Justice in Action, the podcast that takes you inside the criminal justice system so you can see how it works in practice and how it doesn't. This is episode 7 of season 1, Rape on Trial, and I'm Dr Candida Saunders. We're back in court for the third and final part of Dean's trial. He's charged with rape and sexual assault against his then partner, Anya. If you're a new listener, I'd strongly recommend you go back to at least episode 5, where Dean's trial began. Better yet, start from episode 1 to get a sense of how the different trials we've seen compare, not only with each other, but to greater and lesser degrees with what we're told rape trials look like. For returning listeners, great to have you back. Here's a quick recap where we are and how we got here. The jury's now heard from all the prosecution witnesses, the complainant Anya, the arresting officer PC Dudley, firearms officer PC Walker who took her first account, and DC Green, the officer in the case. Mr Peters, counsel acting on behalf of the Crown, he's just told the judge that subject to a ruling from the court on some bad character evidence he wants to adduce, that's the close of the prosecution's case. In other words, if the judge rules that evidence of some or all of Dean's previous convictions are admissible, then the jury is going to hear that, and then the prosecution's case will be complete. If the judge is against him, however, and the application's denied, then the prosecution's case is done now. That application's yet to be heard, Mr Peters having just been told essentially to go home, do his own homework and put it in writing so that it can be dealt with tomorrow. And Mr Charles, counsel for the defence, he then informed the judge that he also has a submission to make, at which point the jury was called back from its break and sent home until tomorrow. So that's where we're picking up from. 3:45, day 3 of trial. Mr Charles's submission is about to be heard. Mr Charles, Dean's defence counsel, is making what's called a submission of no case to answer on count 1 on the indictment, the sexual assault charge. I'll tell you what that is in a moment, but first, to be absolutely clear from the outset, Dean's currently on trial for 2 offences, sexual assault, which is count 1, and oral rape, which is count 2. The defence submission of no case to answer relates only to the sexual assault charge. So what's a submission of no case to answer, or, as it's also commonly called, a half-time submission? It's a submission, a legal argument made by the defence at the end of the prosecution's case that the prosecution hasn't led sufficient evidence to support a conviction on the relevant charge or charges. Following a submission of no case to answer, the judge will assess the evidence heard to determine if a reasonable jury, properly directed, could find the defendant guilty. In making that determination, the judge uses what's called the Galbraith test. There are 2 limbs to the Galbraith test. The first limb is a straightforward procedural manifestation of the presumption of innocence. If there's no evidence that the crime alleged has been committed by the defendant, then, says Galbraith, there's no difficulty. The judge will, of course, stop the case. The second limb is raised where there's some evidence before the court, but it's, quote, of a tenuous character, for example, because of inherent weakness or vagueness, or because it is inconsistent with other evidence. In those circumstances, the judge must consider whether the evidence taken at its highest is insufficient to justify a conviction. If a reasonable jury properly directed couldn't convict on that evidence, then again, the judge should withdraw the charge or charges from the jury. How? By directing, telling, instructing the jury to acquit. It's called a judge-directed acquittal. Formally speaking, the jury acquits. The reality, of course, is that the jury doesn't have any say or any choice in the matter. They don't go off to deliberate, and they cannot decide not to follow the judge's instructions to acquit. The purpose of the Galbraith test is to reduce the risk of a defendant being convicted on the basis of flimsy or otherwise inadequate evidence. It's to ensure that only those cases with sufficient evidence are left for the jury to decide. So in this case here, Mr. Charles's submission of no case to answer relates only to count 1 on the indictment, the sexual assault charge, when Dean allegedly pinched Anya's vagina, and he's making his submission under the first limb of the Galbraith test. Mr. Charles is arguing that there's no evidence of the alleged sexual assault and that charge should be dismissed. In her ABE interview, Mr. Charles is saying, Anya says no more than that Dean was trying to, quote, pinch her bits. She doesn't at any point say he succeeded, and the interviewing police officer didn't at any point ask Anya to clarify that or to confirm that there was in fact a touching. At its highest, continues Mr. Charles, on the evidence presented by the prosecution, there's an attempted touching, but there isn't evidence of an actual completed touching. Now, I don't know whether you noticed this, but during Anya's cross-examination, Mr. Charles didn't ask her any questions at all about the sexual assault in count 1. He asked her briefly about the rape, but he didn't ask her a single question about the sexual assault, the vaginal pinching. His Honour noticed, and the judge is saying now he's been expecting a submission along these lines. The prosecutor also noticed, but Mr. Peters is saying, I didn't think I could ask her to expand on that without leading her. In short then, the judge has been expecting a submission of no case to answer on count 1, and the prosecution isn't resisting it. Why? Well, because there isn't so much an evidential gap as there is a glaring hole in the prosecution's case. There is no evidence that the sexual assault, as it's presented in the particulars of the offence on the indictment, there's no evidence that Dean sexually assaulted Anya by pinching her vagina. There's no evidence that that happened. Anya said he'd tried to pinch her bits. She didn't say he had. And nobody asked her. The police didn't ask her, and they interviewed Anya twice. The prosecutor, Mr. Peters, didn't ask her on any of the several occasions Anya's been on the witness stand over the past couple of days. And the defence didn't ask her, although it's not the defence's job to fill the evidential holes in the prosecution's case. That's the prosecution's responsibility. The defence is not required to prove Dean's innocence or to fix mistakes in the Crown's case. It's up to the prosecution and the prosecution alone to prove its case. And here, in relation to count 1, there's no evidence, no allegation from Anya that Dean actually pinched her vagina, and there's no medical evidence of vaginal pinching, no bruising or other vaginal injuries consistent with being pinched, or indeed kicked in the vagina. Now, there might have been medical evidence consistent with being pinched, but it doesn't sound like anybody looked. There wasn't a forensic medical examination. Anya was taken to hospital by the police that day when Dean was arrested, but at that point she hadn't made any allegations of a sexual nature. The police, and presumably the staff at the hospital, were dealing with this as a domestic violence incident. With no evidence that Dean pinched Anya's vagina, the sexual assault charge in count 1 cannot go to the jury. There's no evidence on which a reasonable jury properly directed could convict. Tomorrow, says the judge, I will ask that a foreman be chosen and the jury will be directed to acquit on count 1. Anything else we can deal with now? No, says Mr. Charles. And with that, court rises for the day. The jury don't know it yet, but there's just been a significant development in Dean's trial. Thursday, day 4 of trial. Today is short and a bit bitty. For a start, there was no court this morning. The judge had other matters to attend to, and the jury had already been told they wouldn't be needed until 2 o'clock this afternoon. With the judge busy elsewhere then, nothing happened in Dean's case at all today until after lunch, and this afternoon was chiefly taken up with legal argument and procedural matters. No evidence was heard. The jury really didn't spend much time in court today at all. On the one hand then, not a lot happens in court today. On the other hand, the not a lot that happens today, well, it's pretty significant. First, Mr. Peters' bad character application is dealt with. Remember, Mr. Peters was seeking a ruling from the judge to allow him to lead evidence of Dean's previous convictions, including the evidence that when Anya collected Dean in the car from what's been referred to so far as simply somewhere, that somewhere was in fact prison. That application's just been dealt with, and it was denied. In a nutshell, the judge reasoned that yes, the defence case clearly amounts to an attack on Anya's character, but whether an admissibility gateway is triggered, whether there's been an attack on another person's character, that isn't the only thing the judge has to consider. Section 1013 of the Criminal Justice Act 2003 adds another vital consideration into the admissibility mix. It says the court must not admit evidence under subsection 1D or G, and 1G is the subsection the prosecutor's relying on here. The court must not admit the evidence if it appears to the court that the admission of the evidence would have such an adverse effect on the fairness of proceedings that the court ought not to admit it. And that, in essence, means weighing whether the prejudicial effect of evidence of Dean's bad character outweighs its probative value. And His Honour determined that it does. Those previous convictions, and there are a lot of them, are more prejudicial than probative. It would be unfair to admit this evidence, so the judge has ruled it inadmissible, which means the prosecution can't adduce it. In perhaps overly simplistic layman's terms, but not, I think, too far off the mark, what's just happened is that the judge has decided that there's so much evidence of just how horrible Dean is. And he's just horrible. There's so much evidence showing that A, he is really horrible, at least to women, and B, that he's been really horrible to women for a long time, that the jury can't hear it. Because they may convict Dean now, not on the basis of the evidence in this case, but on the straightforward basis that Dean is demonstrably, has been proven in the past to be horrible. He's violent, he's dangerous. We don't want juries convicting defendants on the basis that they're awful human beings or have been awful human beings in the past. We want juries to convict a defendant in the light of evidence relating to what he's charged with now, not what he's done before. So beyond what they've already been told about Dean pleading guilty to 3 charges of actual bodily harm against Anya, the jury aren't going to hear about any of Dean's other convictions. They aren't going to be told that Dean's got a string of convictions for violence against women, or that on the day Dean assaulted Anya in the car when she ran into the petrol station begging for help, he'd just been released from prison. And they're not going to be told that at the time Dean pleaded guilty to offences relating to Anya, he also pleaded guilty to numerous charges for assaulting, intimidating and harassing Erica. We will look at bad character in more detail later in the season. For now, though, what else is happening at court today? Well, the next main development is that following his ruling yesterday, the judge has just directed the jury to select a foreperson and to acquit Dean on count 1 on the indictment, which they're doing now. I can't say the jury looks terribly happy about this, but it is what it is. As we've just seen, there isn't any evidence on which they could convict Dean of sexual assault, not as it's set out on the indictment. So in line with the judge's instructions to the jury, Dean's just been found not guilty of sexual assault. That hasn't brought proceedings to an end. Dean's trial continues, but there's only one count on the indictment for the jury to consider now, the rape charge. With all the procedural matters dealt with and with Dean's bad character evidence inadmissible, Mr. Peters confirms that the prosecution's case is now complete. It's the defence's turn. Mr. Charles stands up and informs the court that the defence will not be calling any witnesses. Dean, then, is not testifying, and neither is anyone else. The defence presented its case in the course of cross-examining prosecution witnesses, Anya, the police officers. With no more evidence to be heard then, and the defence case closed, the trial's now in its final stages, which means closing speeches and judges' directions. Now, you might be asking, wait, what? Hang on, what about Jimmy? Why hasn't he been called? There's this lingering dispute between the defence and the prosecution around whether Anya told Jimmy she's going to stitch Dean up. The defence says she has, and Anya said she hasn't. The prosecution seduced rebuttal evidence, not just by asking questions of Anya in re-examination, but also by leading evidence, screenshots taken from Anya's phone showing that the conversations originally suggested by the defence hadn't taken place. But Mr. Charles, of course, then moved the evidential goalpost and said, but actually, we now believe that the conversation took place via Snapchat. And because of the way Snapchat works, that disputed fact can't be settled independently. We've simply got Anya's denial in cross-examination. So you might be thinking, well, then why hasn't Jimmy been called as a witness to settle that issue once and for all? Technically, legally, he could be called. There's sufficient flexibility in the legislation and the criminal procedure rules to allow Jimmy to be called late as a witness. It's quite rare for a new witness to be called at such a late stage in proceedings, but the court might allow it. The reality, though, is that strategically, I'm not sure either party, the prosecution or the defence, would actually want to call Jimmy as a witness. Why? Well, because Jimmy and his evidence, who he is and what he's going to say, whether he's a credible witness, they're all unknowns. Jimmy's not been any part of this case until he popped up out of nowhere, it seems, in Anya's cross-examination. He's never been interviewed by police, he's not given any statements, and there won't be any information in the prosecution file about him, including whether he's got any antecedents, previous convictions, arrests, whatever. So the prosecution would be reluctant to call Jimmy as a witness. There's a risk he might confirm the defence's allegation that Anya is trying to stitch Dean up, which would undermine the Crown's case. But they don't really need to call Jimmy. They've already rebutted Mr. Charles's suggestions by asking Anya about her conversations with Jimmy while she herself was in the witness box. The prosecution's also adduced evidence of the texts between them, which were taken directly from Anya's phone. Plus, of course, the prosecution case is already closed. The defence, on the other hand, well, they're under no obligation to call any witnesses, and they're unlikely to want to call Jimmy because he might flatly and convincingly contradict their angry, vengeful woman trying to stitch up nasty ex-boyfriend narrative, which in turn would bolster the prosecution's case. Because make no mistake, this suggestion of a stitch-up, it's come from Dean. It has to have come from Dean. Dean's told Mr. Charles she's trying to stitch me up, and she's even told her mate that that's what she's doing. If there was solid and reliable evidence from a credible witness that that's what she was doing, Mr. Charles would have led it. Strategically then, from a defence perspective, this issue is probably best left hanging in the air. Either they can't resolve it by calling Jimmy, or they don't want to risk trying. But what about Ryan, you might be asking? Why hasn't he been called? And what about the evidence from the police that Mr. Charles alluded to, showing that Anya had made and subsequently retracted an allegation of sexual assault on the basis that it was false? Well, again, the defence is under no obligation to call witnesses, and again, although I'm speculating, I imagine that calling Ryan as a witness would be A, probably futile, and B, very much a risk. As for the allegation and subsequent retraction, if there was reliable and credible evidence that this is in fact what happened, I'm pretty confident the defence would have led it. So I'm back to that came from Dean, and the defence don't want to either prove or resolve the issue. It suits the defence for it to be left hanging. The entire defence strategy in this trial seems to have been throw as much mud as we can, sit back, see what sticks. That, by the way, is not unique to rape trials. It's standard fare in an adversarial system. It's just been particularly noticeable in this trial. Anyway, back to court. The evidential part of the trial, the hearing from witnesses and so on, that's now done and dusted. It's time for judges' directions and closing speeches. Unlike the judges in Tariq and Jerome's trials, the judge in Dean's case isn't giving split directions. His Honour is going to cover everything, judges' directions and his summing up of the evidence, after closing speeches. That's fairly unusual these days. Most trials I've seen, at least in England and Wales, directions are split. The legal directions come first, then the prosecutor's closing, followed by the defence closing speech, then back to the judge for his summing up. So it's still Thursday afternoon, day 4 of Dean's trial, and we're going straight into closing speeches. Mr. Peters takes to his feet, and I'm not going to cover it here. It's not that it's not interesting, it is, but Mr. Charles's closing, well, it's not just interesting. For anyone who hasn't spent much, if any, time in court watching these sorts of trials, I think Mr. Charles's closing speech is going to be fascinating. A jaw-dropping, eye-opening, perhaps even gobsmacking example of a defence closing speech. I don't think it's what you're expecting to hear, and yet in some ways I think it's exactly what you're expecting to hear, which means I want you to hear it in full, which in turn means I have to make an editorial choice. And that editorial choice is that I'm just going to tell you that Mr. Peters' closing for the prosecution wasn't jaw-dropping. It was fairly predictable and it lasted around half an hour. After that, there were more legal submissions, obviously in the absence of the jury. Then, as it was already well after 4, court adjourned for the day. It's now Friday, the 5th and final day of Dean's trial. It's approaching 11 a.m. and the jury's about to hear from Mr. Charles. Now, what you're about to hear is taken almost word for word from Mr. Charles's closing speech. I say almost because I've obviously had to change any references to real names, and on a couple of occasions, for clarity, I've replaced pronouns with names, just so it's easier for you to follow. But aside from that, I've added nothing, removed nothing, haven't smoothed anything out, and I haven't put in any explainers. So, over to Mr. Charles. There's an expression in English law that it's a jury's pleasure to acquit. And if there is one thing that's certain in this case, it's that if you decide to acquit, it will give you no pleasure whatsoever. In some cases, at the end of the evidence, a jury may feel an affinity with an accused, sympathy, or by the time it's finished and moved on from the prosecution's opening, by the time the case finishes and they've heard the whole story, some flesh and personality put onto the bones of the defendant, the jury comes skipping in, says not guilty, and they're all smiles. And when you were directed yesterday by His Honour to find Dean not guilty on count 1, I suspect that gave you no pleasure. It gave you no pleasure to hear those words. Is it not true that this case couldn't be further from the type of cases I've been describing? On any view, even on Dean's own view, as in what his defence is, there can be no doubt that he's a repugnant young man deserving no sympathy from any of us, and in particular from any of you. The behaviour you've heard about, admitted behaviour by him and Anya, is inexcusable, despicable, appalling, cowardly, vicious and heartless. I suspect each of you could come up with similarly uncomplimentary words. Dean is a horrible young man who showed no mercy to Anya, and you might be forgiven for thinking he deserves none from you. I would ask you to step back and consider this. Don't think he's going to get away with what he's done to Anya. There's no secret about it. Prison is where he belongs. Rest assured that's where he's going, because the judge will be sentencing Dean for the offences he's pleaded guilty to. The whole point of this process is that all of us have our jobs to do. We're all under a duty. It's Mr. Peters' job to prosecute. He calls the evidence and presents the prosecution case to you. He does it properly and fairly. That's his job. My job is to challenge the prosecution's case on the basis of my client's instructions. He tells me what happened, and I challenge on that basis. The judge's job is to act as a referee and ensure the trial is conducted fairly. Sentencing is also his job. Punishment is his job, not yours. Your job is the most important, though. We ask the questions, the prosecution makes the allegation, we defend it, and the judge sets out the parameters. Your job, your duty, is to provide the answer. That is your most singular important task. You told all of us what your job was when you took the affirmation to faithfully try and give a true verdict according to the evidence. Everything we do has a purpose. The one thing the judge won't tell you to do, but you take it upon yourself by taking that affirmation. He's going to give you lots of directions, and you don't take affirmation about those, but you do for trying a case on the evidence. It's not easy in this case, but you have to examine the evidence dispassionately and fairly. It's a serious allegation, but a simple issue. In the course of his repeated physical abuse of Anya, did he force her to perform oral sex on him? There are 2 verdicts available to you, guilty and not guilty. There's no such verdict as innocent. We don't ask that. What it really comes down to is this. Are you sure or are you not sure? Because not guilty means nothing more than I'm not sure. Bear that in mind when you consider being true to your oath to try this case on the evidence and give a true verdict. All of us would like nothing more than for Dean to be locked up and the key thrown away. But there's a process. So, to the evidence and the framework for you to approach it. The judge is going to tell you, rightly, that there's no correct way for a victim of rape to behave. Experience has told us that they react in different ways, and you can't expect them to do a certain thing. But here, and it's in evidence, Anya made no mention whatsoever of being raped when police attended the address. We had PC Dudley on the screen and another officer's statement. They noticed her injuries were fresh and she said, "Thank you for coming." She was relieved the police were there. She didn't tell anyone about being raped. She's then video interviewed the next day and again says nothing about it until some time into her account. In the first bit, where she gives her long account. But do you remember? She says that she's there to talk about being beaten up by her boyfriend. I know the prosecution has tried to say that Dean's defence is that this was a deliberate, sinister and calculated attempt by Anya, that she's going to make this allegation up. But we say it needn't be as calculated and sophisticated. It may have been made on the spur of the moment. We're all guilty of telling stories, and things get embellished to make for a better story. What we say is that maybe on the spur of the moment you have an exaggeration of the violence towards her. Maybe it's important that this is the first time she's mentioned it to police. We only ask you to consider why, if the allegation is true, why not mention it earlier? And she did say when I asked her that she'd spoken to a friend and she'd said Anya had to tell the police. So why did she not say that to the police at the beginning? Why not at that point? In English law, we have the concept of recent complaint, so that if someone, for certain reasons, doesn't tell the authorities that they've been raped, the prosecution can call a witness to say that they'd been told that something had happened, and that's evidence of it being complained of. We don't have that here. Anya says she told her friend. If so, the prosecution can call that friend to say, "She told me this." But we don't have that here. There's no complaint until sometime through the ABE video. Also, look at the description of the alleged incident. It's not a criticism, but they kind of have 2 goes. There's the video and they play that to you, but they interview her again to clarify certain aspects that weren't clear. You may think there's some inconsistency regarding whether he ejaculated. She says yes in the first interview, she said no in the second, and I don't know in court. So if it happened, there's an inconsistency in her description of it. The officers at the scene weren't sexual offences investigation trained officers. They were firearms officers. And the reason they weren't trained in sexual offences is that nobody was expecting this to turn into an allegation of sexual assault. So the police said yesterday that it's not their fault that important forensic opportunities were lost. They were lost due to her failure to disclose what she now says occurred. The police would, you might think, have taken a sample of the blood. If Dean's semen was in that, then that would have been the end of the case. And you can't speculate, but it may have helped. It would have helped. There's nothing to support what she alleges. She says it happened, and that is the beginning and the end of the prosecution's evidence. You can't help feeling sorry for Anya. You can't but admire her courage in reporting and supporting the prosecution and coming to court. But don't confuse that for reliability and credibility or consistency. Mr. Peters says all this about Ryan is a red herring and doesn't really help you, and she was attacked by him anyway. You're not tasked with deciding whether Ryan sexually assaulted her, but it is important because it demonstrates her inconsistency. She said he'd sexually assaulted her and then emailed police saying he hadn't, that she'd lied about that. It's very difficult with Anya to be sure she's a witness of truth. Even with Ryan, yes he did, she says, no he didn't, yes he did. And that's the point. In the absence of supporting evidence or a recent complaint, Anya told me right after it happened, or forensics showing semen in the vomit sample, but something beyond her word. You don't have it. Being true to your oath, can you rely on that word without something to support it? His Honour will direct you that you don't have to resolve all the contentious issues, just those that assist you in reaching a verdict. The question of whether the passport was ripped up, it was obviously ripped up in the summer, and I'd put questions on instructions that suggested the passport was ripped up the following winter. Either Dean deliberately lied to me or he's mistaken about the timing. He didn't deny doing it. But my point is, does it matter? Either he lied or he made a mistake, but he accepts he ripped her passport up. It's another example of his despicable behaviour, but does it help you in determining whether he raped her? Similarly, Jimmy, whether it was Facebook, Snapchat, whether they spoke or texted, these were explored, but does it help? It's a matter for you. I can't imagine you're going to spend much time considering that because you may think it's irrelevant to the matter in hand. So what about Dean himself? I haven't been complimentary, which he might not like, but I don't care. It's not my job to be his friend. And in some ways, the less said about him, the better. But he has pleaded guilty to the ABH charges. He has recognised he's guilty, and he'll be punished for that. So what about as far as these allegations are concerned? The prosecution invites you to hold it against Dean that he said nothing in his interviews. I know that the judge is going to direct you not to hold that silence against him. I could tell you why, but I don't need to. The judge will tell you why. So ignore the prosecution on that. His failure to give evidence is something that you may hold against him. The prosecution is relying heavily on this. It's what Mr. Peters started and finished with in his closing speech. He complained about being deprived of the opportunity to ask questions of Dean's behaviour. He had lots of things to say about this. But you can only hold it against Dean if it's fair and if the prosecution case is sufficiently strong that it calls for an answer. I submit it is not. It is literally her word and nothing else. Even if you think you still would have liked to have heard from him, it might be interesting to hear from him, but it doesn't work like that. It's not a game, it's not TV, it's a legal process. But let's imagine if he did give evidence. I've already addressed you as to the circumstances he has to overcome to be tried fairly, and I've had to grasp the nettle that he's a pretty appalling individual. But put that to one side. Imagine what it would have been like if he'd given evidence. He'd have had to explain how he beat her over the course of a relationship that lasted months. The revulsion you would have felt for him. And that's just him answering my questions. And then Mr. Peters would have asked about these attacks. It would have left Dean in an impossible position. Who'd come out of that exchange looking better, Mr. Peters or Dean? The only issue that matters is the allegation of rape. You know what his case is. It didn't happen. It's not, yes, she did perform oral sex on me, but she was consenting, or I believed she was consenting. There's nothing more he can say than I've put to her. It just didn't happen. Is it really fair to hold his silence against him, for him not having the courage to confront you and tell you all the horrible things he's done to her in a fit of rage, but in the sober atmosphere of the courtroom, with the prosecution winding him up? The defence is as clear as anything. He doesn't need to take the stand. Dean is up against it because of who he is, and in the current climate in relation to the serious issue of violence against women, hold what he's done against him by all means, but not in a way that interferes with your oath to give a true verdict according to the evidence. As much as it will give you no pleasure, and much as it will stick in your craw, the prosecution's case is weak. It's the word of Anya, and her word is not sufficiently reliable to make you sure. Sure or not sure? That's the only question. Your true verdict must be one of not guilty. After a 10-minute break so the jury can stretch their legs, we're back in court and moving straight on to judges' directions and summary of the evidence. We're going to cover judges' directions in Dean's case in detail. Why? Well, first, because like defence counsel's closing speeches, judges' directions are a vital, critical element of the trial, but they're woefully underreported in either the press or the research literature. And where they are discussed, they're often misunderstood or trimmed down to the point of being on the cusp of misrepresentation. Yet, despite the lack of meaningful engagement on the critics' part, judges' directions, like defence counsel's closings, are subject to heavy criticism and demands for reformist intervention. The second reason we're going to hear them in detail is because of the way this case has played out so far, and in particular, the way the defence has been conducted. So, like we just did with Mr. Charles's closing, we're going to look at judges' directions in detail. It's just after 11:45. His Honour starts by telling the jury that there is only one issue for them to decide in this case. Have the prosecution proved so that you are sure that Dean orally raped Anya? There's no issue that Dean assaulted her on either occasion. He's pleaded guilty to both. And while he'll remind them of the evidence later, he says, it's not suggested that the catalyst for these assaults was anything other than jealousy. Anya said that the second and third assaults on the indictment, the later assaults, came about because Dean thought she'd been with another man after he'd assaulted her in the first assault he's pleaded guilty to. He tells the jury that Anya said that Dean raised this same issue again. She's tried to placate him, kissing and stroking him, and that she consensually gave Dean oral sex. She said this didn't calm him and that Dean was forcing himself on her so that she no longer consented and made plain that he should stop. The prosecution says that account is credible and reliable, that you can be sure it occurred as described. Dean, through counsel, says the opposite. He says that there was no sexual activity at all and that Anya has exaggerated or embellished her account of the assault to include an allegation of rape. The defence submits that it's false and that when you consider all the evidence and apply the law as directed, you cannot be sure of guilt and are compelled to find Dean not guilty. The judge now takes the jury through the necessary directions. As well as hearing them from the judge now in open court, the jurors have the directions you're about to hear in writing. The first direction His Honour gives is on the functions of the judge and jury, that it's the judge's role to decide the law and it's their job to decide the facts. And they do that based on all the evidence, agreed and challenged. How to interpret the evidence, he says, is a matter for you and you alone. His Honour says that it is also his role to summarise the evidence and that when he does, he will do his best not to emphasise, comment or express a view. If I do, he says, it's irrelevant and you should disregard it. The same goes for his view of the evidence, he says, and counsel's speeches. The judge now moves on to the burden and standard of proof. It's for the prosecution to prove guilt, he says. It is not for Dean to prove his innocence. How do the prosecution prove guilt? By making you sure, he says. Nothing less will do. If you are sure of guilt, the verdict must be guilty. If you are not sure of guilt, the verdict must be not guilty. The indictment, he says. Before you can convict, His Honour tells the jury, the Crown must satisfy you so that you're sure the allegation Anya makes did, in fact, occur. Through cross-examination, it's been put to Anya that the allegation is manufactured, that she's embellished her account to extend the assault she suffered to falsely include an allegation of sexual offending. Although the most contested issue is whether there was sexual activity at all, you must consider all the elements of the offence. Any failing on the Crown's part to make you sure will result in a not guilty verdict. The judge now gives the jury what's called a route to verdict. The route to verdict is basically a roadmap for the jury to follow when it's deliberating. Again, just to be clear, the jury has a written copy of the route to verdict in addition to hearing it from the judge now in open court. The route to verdict is basically a series of factual questions based on the relevant law and the issues and the evidence in the case that one by one lead the jury to a legally justified verdict. So, says the judge, the prosecution needs to make you sure of 4 things. 1. That Dean penetrated Anya's mouth with his penis. Dean denies that this occurred. If the Crown has made you sure Anya is an honest and reliable witness in describing this, then you can move on to question 2. If you're not sure, deliberations end there and the verdict is not guilty. Question 2. When he did so intentionally. The penetration must be deliberate, not accidental or reckless. It's a matter for you. If you're sure penetration was deliberate, then move on to question 3. But if you're unsure, it ends there. Question 3. You must be sure Anya did not consent to the penetration. He tells the jury that consent is defined in law as agreement by choice and having the freedom and capacity to make that choice. You will decide whether Anya had the freedom and capacity by considering the circumstances at the time as you find them to have been, the judge says. Dean, he points out, hasn't said Anya consented. He says it didn't occur and Anya's fabricated the allegation. So he doesn't suggest that you should conclude she was consenting, says the judge. There is no dispute, continues the judge, that on this date Dean had assaulted Anya, and the law provides that Anya is to be taken as not consenting if, at the time of the act or immediately before it, the defendant used violence against her or caused her to fear immediate violence would be used. If you're sure that at or immediately before Dean penetrated Anya, he used or caused Anya to fear violence, then she's taken to have not consented. If you're sure Anya didn't consent, go to question 4. Question 4, says the judge, is has the Crown satisfied you that Dean did not reasonably believe Anya consented? Whether a belief in consent was reasonable is considered in all the circumstances, including any steps taken to ascertain consent. Dean says it didn't happen, says the judge, so he's not asking you to consider his belief. But, again, the law provides that Dean is taken not to have reasonably believed Anya consented if he used violence against Anya or caused her to fear immediate violence. If you're sure Dean did not reasonably believe Anya was consenting, the defendant is to be found guilty. Evidence, says the judge. You've heard all the evidence from both sides that you're going to hear. You will hear no more, he says. They must try the case on the evidence they've heard. They're not to speculate on what else there might be, whether that's witnesses they might expect to have been called or any other matter. The parties decide what evidence you'll hear, he says, and that's concluded. Don't ask for further evidence. He has to remind the jury, he says, that the defendant has no obligation to call any evidence at all. It's up to the Crown to call evidence that makes you sure of guilt, he says. If you're not sure, he cannot be guilty. You don't have to decide all the issues, the judge says, just those that need to be proved by the Crown. It's up to them whether they accept or reject anyone's evidence in its totality or in part. He tells the jury they're entitled to draw inferences. This, he says, is different to guessing. Inference has a proper evidential foundation, and the jury must be able to rule out any innocent explanation that might benefit the defendant. Guarding against assumptions, says the judge. When judging allegations of sexual assault, experience shows it is necessary to keep a cool head. It is easy to feel indignant at the idea of this sort of thing happening, he says, and it's easy to sympathise with a witness called to recount an alleged incident that she says was distressing and unpleasant. Those are perfectly proper and normal emotions, he says, but they don't assist in deciding whether the allegation is satisfactorily proved. He tells the jury they must take a clinical approach to the evidence and shouldn't allow emotion or sympathy for any party to influence them. It's understandable, he goes on, if you or others come to this trial with assumptions about who is a victim of sexual offences, who commits these offences, or what a person who's been assaulted will do or say. You might have read in the media about whether people in these cases tell the truth or tell lies. It's important you leave behind these assumptions because experience tells the court there's no stereotype re who is a victim or a perpetrator. Sexual offences can happen in almost any circumstances between all kinds of people who react in different ways. Approach the case dispassionately, the judge tells them, putting aside any view as to what you might or might not have expected to hear. Make your decisions strictly on the evidence and law as I've explained them. I've already directed you about the special measures used in this trial, he says, but it is important you fully appreciate why they are used. Such measures are employed to provide for you the best opportunity to receive evidence. Giving evidence is daunting, and the quality of a witness's evidence might be diminished if the witness is ill at ease. Police and the courts now routinely implement special measures designed to make witnesses feel more comfortable, he says. He explains the purpose of the special measures used during the trial, that pre-recorded video interview enables a witness's account to be captured at an early stage of proceedings with specially trained officers. The use of the screens during Anya's cross-examination, he says, is to make the witness feel as comfortable as possible while protecting them from the public gaze. These special measures undoubtedly help you, he continues, because the witness feels as comfortable as possible without losing the opportunity for you to see and hear her account. You must understand, he reiterates, that special measures don't reflect on Dean and shouldn't prejudice you against his case. He mentions that PC Dudley had also given evidence using special measures, this time via video link. Again, he tells the jury, this doesn't diminish his evidence and shouldn't reflect adversely against Dean. Now, the judge says, the evidence. He now summarises all the evidence the jury's heard. Now, the word summarises, that's one of those vague and ambiguous words that sounds like it's telling you something, but in reality doesn't tell you anything much at all. A summary can be a quick 3-bullet point overview or a comprehensive walkthrough. In court, judges' summaries are very much the latter. It's a comprehensive recounting of the evidence, witness by witness, claim by claim, and counterclaim by counterclaim. The judge is going through Anya's evidence like this now, her 2 video interviews, and what she's agreed, what's disputed during cross-examination, what she's been asked and what she's said in reply, what she remembers and what she doesn't remember. His Honour recounts the chronology of the events Anya's described in her interviews, her deciding not to come back to the UK while she was at the family wedding, Dean's threatening and abusive messages, including the video of the couple having sex being posted on social media and the message that was attached to it. He summarises her evidence relating to the second assault, that Dean had kicked off when he learned that Anya had stayed with a friend following the first assault. He recounts Anya's description of this prolonged assault, her description of events. what, according to Anya, Dean had done, what he'd said. When he gets to the part of Anya's account where she said Dean had tried to pinch her bits, his honour momentarily sidetracks. Recall, he says, I directed you to return a not guilty verdict, that was significant. He then returns to Anya's ongoing account of the night's events and the following day. It's all very detailed. In cross-examination, says the judge, she agreed she didn't have an interpreter, but she'd seen the videos and everything she said was true and accurate. Not grammatically correct, but the meaning was what she'd wanted to say. She agreed that they'd argued about her being unfaithful, that he wouldn't let it go, that it had started on the sofa and continued on the stairs. She agreed she'd hit him with a pipe, that she'd called him a bastard, and that his finger had been hurt when he raised his hand to defend himself. That she agreed Dean had then punched her in the face and that she'd punched him and hit his nose, that he'd gone to the kitchen, that she couldn't remember going to the kitchen and didn't remember getting a steak knife to clean her nails or sitting on the sofa saying it shouldn't have happened. She said he did strangle her and that she was losing consciousness when it was suggested to her that it didn't happen. Asked about her injuries, says the judge, she didn't remember if there was bruising to her neck. The suggestion was put to her that they hadn't left the house, that she'd stayed home and hadn't seen anyone else. She disagreed, and she disagreed when it was put to her again. He recounts that questions were put to Anya in cross-examination about her passport and that it had been suggested that the front cover of her passport had become detached, that she was nervous she wouldn't be allowed to travel, and that that's why they'd gone to the embassy. She said no, he ripped it up. It was put to her that this happened later, in the winter, and she said no, in the summer, and that the dates are on the passport. You have seen a copy of that, he tells the jury. She was asked about the police attending the house. She agreed that she'd told police he beat her up, but not that he had raped me. I'd not forgotten. I was embarrassed and didn't want to tell. She said they didn't ask if she'd been raped, she hadn't told them she had been sexually assaulted at that time, and that she wouldn't have done unless they'd asked. She didn't mention it because she'd been subjected to all this for 2 days and was embarrassed and didn't know who she could trust. Between the arrest and the police interview, she spoke to a friend who said she had to tell police everything, that he had to pay. He says that Anya agreed in cross-examination that she didn't make any mention of sexual assault until the video interview, that it was put to Anya in cross that no sexual assault had occurred and that she was embellishing her account to make things worse for Dean because she was angry at him, that she denied that she'd said she wasn't embellishing. He recounts that it was put to her that she'd taken a truthful incident, the assault, and mixed in some lies, that this, again, Anya denied. It was suggested to Anya that if it was truthful, she'd have said at the beginning that she'd been beaten up and raped. She said no. She was taking it a step at a time. She said, I've not made any lies up. Back to the directions, says the judge. Delay. It was put to Anya in cross-examination that she'd not reported the sexual assaults at the first opportunity when police arrived at the house or immediately when she was videoed the next day. She accepted this, says the judge. The defence case, he continues, is that no sexual assault occurred and her allegation is malicious because she wants to punish Dean. You must come to this issue with no preconceived ideas about how people behave in this situation, says the judge. It is wrong to assume everyone victimised will report as soon as possible. People react in different ways. Some in distress or anger may complain to the first person they see. Others, in shame or fear or shock, do not complain for some time. There is no classic or typical response. How a person reacts might not be what you'd expect or what you'd do. A delayed report does not necessarily signify a false complaint, just like an immediate complaint is not necessarily a true one. It's a matter for you to decide, says the judge, whether delay assists you and what weight to attach to it. Consider what she said about her experience and what the defence has said about it. She's told you that she didn't mention it immediately because she'd been subject to abuse for 2 days, didn't know who to trust and was embarrassed. Between Dean being arrested and her being interviewed, her friend told her to tell the police, and she's given a complete account in her interview and said that this was true. Fundamentally, says the judge, you must decide if events occurred in the way described by the complainant. Only if you are sure she is an honest and reliable witness can you convict. That assessment is for you and you alone. The judge now returns to his detailed recounting of Anya's evidence, that she felt strongly Dean mistreated her, that she agreed he should go to prison for a long time, and that she understood the rape allegation made it more serious. The passport, the alleged telephone conversation with Jimmy which Anya denied, the incident with Ryan and her evidence on that. He then moves on to summarise the evidence from PC Dudley, who appeared via the video link, then to PC Walker, whose statement was agreed by the parties and read into evidence. And then, finally, he summarises the evidence of the officer in the case, Detective Constable Green. Again, the judge's summaries are detailed and comprehensive. He summarises what each witness said in their evidence in chief and what they said in response to questions and submissions put to them in cross-examination. It's all evidence, he tells the jury, and it all needs to be considered by the jury. Incidentally, the judge makes explicit reference to it being put to DC Green that no complaint of a sexual nature was made until 45 minutes into the video interview. That, says the judge, was by mistake. It was about 9 minutes. Back to the directions document, he says, for what purposes may the jury use Dean's previous convictions? You've heard, he says, that Dean has pleaded guilty to assaulting Anya on 2 dates. The evidence concerns events prior to the date of the alleged rape. Both the prosecution and defence agree that this is relevant and you should have this evidence before you, but for different reasons. The prosecution case is that Dean's violence on previous occasions continued so as to include sexual violence, a rape. These previous assaults demonstrate that Dean has a tendency to be violent towards Anya, and so it is more likely that he was violent towards her on the relevant date and that his offending escalated so that he committed the act of rape she alleges. The defence suggest that his pleas of guilty demonstrate only that he's accepted responsibility for the physical violence used. The defence case, says the judge, and which was put to Anya, is that she's embellished or exaggerated her account to falsely accuse Dean of sexual offending, done maliciously, intending to get him into more trouble. It is up to you to decide whether this evidence does show a tendency to behave the way the prosecution submit. If you are not sure that these admitted assaults show that he has such a tendency, then you must ignore this evidence as it has no relevance to the issue in the case. But if you are sure it does show such a tendency, then this may support the prosecution. It's up to you if it does, and to what extent. But the fact that someone has accepted that they've assaulted their partner previously doesn't prove that he did in the way alleged, rape, on this occasion. This evidence can only be some support. You must not convict wholly or mainly because of it. Finally, says the judge, Dean's silence when he was interviewed by the police and at trial. Dean was interviewed by police and he replied no comment to questions put to him. He was entitled to remain silent, he tells the jury, and you should draw no adverse inference against him for having exercised that right. Dean has chosen not to give evidence, he continues. That is also his right, but, says the judge, it has these consequences. 1. Dean has not given evidence to contradict or undermine the evidence of Anya. Instead, through counsel, he has put a case suggesting the allegation is false. He has not provided any evidence on oath that can be tested through cross-examination. 2. Remember, I asked Dean's advocate if Dean was going to give evidence. He told us that Dean understood that if he failed to do so, you would be entitled to draw inferences from that failure. In other words, that you would be entitled to conclude that Dean didn't have an answer to the prosecution case that would stand up to cross-examination. It is your decision whether his failure should count against him. You can only hold that failure against him if you are sure the prosecution's case is so strong it calls for an answer, and that the true reason for not giving evidence is that Dean does not have an answer that would stand up to cross-examination. Remember, it is for the prosecution to prove guilt. Failure to give evidence can provide support, but you cannot convict wholly or mainly because of that failure. I have one final direction, he says, which we'll do after lunch. After lunch, His Honour gives his final direction. While the jury will have seen and heard about majority verdicts, he says, they must put that out of their minds for now. They must reach a unanimous verdict, a verdict of either guilty or not guilty, on which they all agree. A majority verdict is not acceptable at this stage. And with that, the jury's put in the charge of the usher, and they're led out of court to begin their deliberations. OK, so the evidence is done. Both barristers have said their piece. The judge has given the jury its directions. He's summed up the evidence and he's told them to put majority verdicts out of their mind. The jury's out and all we can do now is sit and wait. While we're waiting, I've got a couple of questions for you. My first question is this. What do you think? What's your verdict? I know you haven't heard everything. You've had a comprehensive retelling, which, if you've listened from the start, is a good 3.5 hours of detailed recounting. But you haven't heard everything, and you haven't seen anything. But you've heard plenty. And you know more than the jury. Evidentially, you've heard the same evidence and legal arguments the jury heard, albeit edited down. You've heard the judge's directions, where he spelled out the 4 questions you need to answer, the steps you need to take to reach a verdict. He's told you how confident you have to be that Dean did what he's accused of before you can convict. You must be sure, the judge has said, nothing less will do. So take a moment. Evidentially, no, you're not in the same position as the jury, but that's okay. You don't have the same burden of responsibility as the real jury here. Your answer has no bearing whatsoever on Dean. You can make a decision here without worrying that you've got it wrong. And there isn't a wrong answer. The question the jury's asked is, are you sure? You can't get that wrong. Either you're sure or you're not. So, based on your dispassionate and impartial assessment of the evidence presented, putting aside any assumptions or preconceptions you may have about rape complainants and perpetrators, are you sure Dean forced oral sex on Anya? If you are sure, then he's guilty. If you're not sure, then it's not guilty. What's your verdict? And here's my second question. Based on everything we're told about rape trials, what verdict do you expect the jury will return? Because if we filter this case through the research lens that says juries' deliberations are prejudiced by rape myths, well, then this case has got pretty much everything going against it. For a start, it's an intimate partner relationship rape. Cases involving current or former partners are consistently shown to be especially prone to attrition. In comparison to other categories of complainant-defendant relationship, they're the least likely to result in charges and the most likely to result in acquittal. In terms of the rape myth narrative, then, an intimate partner relationship rape falls foul of the so-called real rape myth. The reported belief that only a blitz attack by a knife-wielding stranger, the man-in-the-bushes type narrative, is a real rape. An intimate partner relationship is possibly as far away from the so-called real rape as you can get. Arguably, one of the key difficulties, at least on the mainstream approach, is that it adds complexity to the issue of consent, which, to be fair, isn't an issue in Anya's case. Dean's not saying it was consensual, he's saying it never happened. It's a flat-out denial. According to Dean, there was no oral sex, it didn't happen, she's made it up. Which raises yet more rape myths, all linked to Anya's credibility. Dean's defence, in a nutshell, is that Anya's lying. It took her a beat to come up with the lie, according to the defence, hence the delayed report. But she is lying. She's got motive to lie, she's angry and vengeful. She's told her friend Jimmy she's going to lie, and, what's more, she's lied before. She falsely accused her ex-boyfriend Ryan of sexual assault about a year before she met Dean. Then we've got this notion of the ideal victim. As much as society apparently expects real victims to fight back, Anya's landing a few good punches, hitting Dean with the pipe, and according to Dean, but disputed by Anya, arming herself with a knife, has been presented as retaliation and anger more than self-defence. Mr. Charles hasn't said this explicitly, but given what we're told about jury deliberations, they could feasibly reason along the lines of, well, if it did happen, why didn't she resist? She fought him off when he was hitting her. Why not now? There are, on the mainstream approach, lots of reasons the jury isn't going to believe Anya. Rape myth-based reasons that we're told are overwhelmingly evidenced in the research literature. Then there's her inconsistency. She's told the police Dean ejaculated, then that he didn't, and then told court she didn't know. The contact with Jimmy. First she said no calls, then a missed call, then no Snapchat, then yes, Snapchat, but she couldn't remember what she'd said. There was a fair amount of that too, Anya saying I don't remember. Probably because she was rattled and taken aback during a cross-examination that looked far more like an ambush than anything we saw in either Tariq or Jerome's trials. 2 ambushes, in fact. Those questions about Jimmy and Ryan, they seemed to come out of nowhere. She clearly wasn't expecting them. And even though Mr. Charles's suggestion of a previous false allegation wasn't clearly established on the evidence, it certainly wasn't proved. But again, according to the mainstream, that doesn't matter. We're told the mere suggestion of a false allegation in the past can poison jurors' perceptions. In all, at least in terms of the cross-examination of complainants, Anya's cross was more adversarial, more combative than we've seen so far. And while she neutralised some of the suggestions put to her, like the passport, and perhaps to a lesser extent the suggested phone conversation with Jimmy while she was waiting to take the stand, other issues, credibility issues, were not resolved, but rather were left hanging in the air. And that will matter because there's no corroborative evidence. No witness saying, yes, Anya told me about this. No supporting forensic evidence. No semen in the vomit. In fact, according to the defence, no vomit. This is literally a case of one person's word against another's. And that, according to the mainstream account, just isn't enough. We're told women aren't perceived to be credible witnesses. They're not believed. And here, the defence has basically said to the jury, you shouldn't believe Anya. She's got motive to lie. She's told Jimmy she's going to lie. She's lied before. She's lying now. And she's not doing it very well. Look at all the inconsistencies. So, once again, we've got the wrong kind of rape, the wrong kind of victim, a delayed report, credibility issues, inconsistencies, the lingering whiff of a previous false allegation, and a defence barrister who has pulled no punches. But I'm going to go out on a bit of a limb here. I'm going to guess that you, or at least a hefty chunk of you, think Dean's guilty. I'm also going to guess that given all the problems I've just highlighted and what we're told about jury deliberations in rape cases, that they're biased by rape myths and gender stereotypes, I suspect you think the jury's about to acquit. You might even be wondering how this case ever got to court in the first place. So what did the jury decide? The jury returned its verdict on Monday. Dean was convicted of rape. Another rape trial, then, that according to the mainstream narrative was the wrong kind of rape and the wrong kind of victim, the kind of case that shouldn't succeed, but did. Dean was convicted, just like Tariq, just like Jerome. Now, I started Dean's trial back in episode 5 by asking, what's happening here? What are we seeing? Is this an emerging pattern, or were Tariq and Jerome's trials just a couple of random flukes? Let me answer that directly. This is a pattern, and it's not a pattern I'm inferring from 3 trials. It's a pattern that has been documented for years in the criminal justice statistics. Juries convict in rape cases. In fact, they convict more often than they acquit, and they've been convicting more than they acquit for a very long time. Professor Cheryl Thomas's research shows that over a 15-year period, juries in England and Wales convicted, on average, in 58% of rape trials. And while the conviction rate fluctuates year to year, overall, the rape conviction rate at trial has been increasing over time. It was 75% in 2021. If you trawl through Crown Prosecution Service annual data summaries and its Violence Against Women and Girls reports, or the Ministry of Justice Criminal Court statistics, you'll find the same. A guilty verdict is by far the most likely outcome in a rape trial. The problem, of course, is that not all, and in fact not many, rape cases actually get to trial. We'll get to that later in the season. But right now, we're interested in trials and the reality that if a rape case gets to trial, the jury is significantly more likely to convict than it is to acquit. Now, if you're surprised by that, you're not alone, because the dominant narrative tells us repeatedly that juries in rape trials are biased, that their verdicts are prejudiced by rape myths, gender stereotypes, and rape culture, that as a result of these myths and stereotypes, convictions are rare, exceptional, against the odds. But they're not. Juries convict, and they convict more than they acquit. So why have I just spent 7 episodes painstakingly walking you through 3 trials that all resulted in convictions? Why didn't I just kick this season off by pointing to the statistics? Well, I didn't do that because the pattern I'm actually showing you isn't, look, juries convict sometimes. It's not even, look, juries convict most of the time. The pattern I've been showing you is that juries convict in cases that are the most obviously vulnerable to rape myths, cases that, according to the mainstream, are least likely to succeed at trial. Tariq's trial, one person's word against another's, no injuries, no forensics, swimwear photos, delayed report, young black complainant, and a defence claiming false allegation after regretted consensual sex. Jerome's trial, one person's word against another's, once Jerome admitted he was the man at the scene anyway, sex worker complainant, no injuries, no forensics, delayed report, the complainant didn't even contact police, they contacted her, and a defence claiming she's lying because Jerome stole her money. Dean's trial, intimate partner rape, delayed report, one person's word against another's, cross-examination with multiple credibility attacks, motive to lie, suggestion she'd told a friend she was going to lie, the suggestion of a prior false allegation against another ex-partner. According to the mainstream narrative, the dismal, pessimistic account of rape in the criminal process that dominates the public discourse and informs public perceptions, these 3 cases had pretty much everything going against them. That's why you've heard them. That's why I took you to court with me. To problematise the mainstream narrative, to challenge the conventional wisdom. If rape myths dominate jury deliberations, these are precisely the cases where we'd see that most clearly. These aren't the easy convictions, the stranger attacks with forensic evidence and immediate reports. These are the hard cases, the ones that should fail if the conventional wisdom's correct. But they didn't fail. They resulted in convictions. So moving forward, we're asking a different question. Not whether this is a pattern. It is. A clear, unambiguous, well-documented pattern. The question now is what explains it, and appeals to the operation of prejudicial rape myths. They don't explain these outcomes. Tariq's, Jerome's, Dean's trials, a detailed examination of those 3 trials suggests a jury's verdict turns on evidence, not rape myths. So let's test that. Let's grasp that nettle. Rape myths or evidence? That's what we're asking now. Rape myths or evidence? And cards on the table time, I believe it's evidence. But belief isn't enough. Let's test it properly, the scientific way. Let's try and falsify my working hypothesis that jury deliberations in rape trials are grounded in evidence and proof, not rape myths. Let's set about trying to disprove that hypothesis. Now, I know, and you probably know too, that there's an extensive research literature that purports to show jury deliberations in rape cases are prejudiced by rape myths. Following her recent review of the research, Fiona Leverick concluded in 2020, and has repeated several times since, that the evidence is overwhelming. Quantitatively, at least, I agree with her. The research base is vast, and the findings are consistent. Jury deliberations are prejudiced by rape myths. Qualitatively, though, the body of work Leverick evaluated is deeply problematic. Well, two bodies of work, actually. Leverick looked at rape myth acceptance studies and mock jury research. Both are deeply problematic methodologically. We'll go through the many and varied problems with both research methods in later episodes. For now, I'm simply pointing out that we know the research exists, we're just not relying on it. First, because methodologically the research is fundamentally flawed, and second, because it doesn't stack up. If juries genuinely can't see the evidential wood for the rape myth-riddled trees, why is the conviction rate at trials so high? How and why do juries keep convicting, even in cases like Tariq's, Jerome's, Dean's? And we can't ask them. The secrecy of jury deliberations across the UK is a fundamental, albeit contested, aspect of the criminal process. Juries do not, and in law cannot, explain their reasoning. It would be a contempt of court if they did. So we can't observe their deliberations. Juries can't tell us how they decided whether to convict or acquit in a particular case, and we're not allowed to ask. But what we can do is what we have been doing. We can watch real trials. We can sit in the public gallery day after day and observe the evidence juries hear, the arguments that are made. We can see how the various witnesses testify, how they're cross-examined. We can hear the same opening speeches and closing arguments the jury hear. We can hear the legal directions and summaries of the evidence, and we can see what verdict the jury returns. We can't know what happens in the jury room, but we can know what went into the jury room, and we can see what comes out of it, what verdicts are returned, and we can assess whether those verdicts are more persuasively and consistently explained by rape myths or by evidence. Join me in episode 8. We're going back to court. If you've got questions or comments about anything raised in this episode or anything else this season, I'd love to hear from you. Email me at host@criminaljusticeinAction.com. If you've been affected by any of the issues raised, please visit our website, criminaljusticeinAction.com, for information about help and support. Criminal Justice in Action is a Scrutiny Media production. Researched, written and presented by Dr Candida Saunders. Edited and produced by Candida Saunders and Gary Saunders. Music by Elena Smanova.